Every so often, the court takes a magnifying glass to a small but powerful part of a law. In Martin v. United States, the justices looked at one section of the Federal Tort Claims Act, the rule about when someone can sue the federal government. They said the special law enforcement safety net only applies if an officer meant to do harm. It doesn't wipe out other rules that protect government choices or other exceptions. They also made clear that the Supremacy Clause, often used to shield federal actions, can't be used here to block claims. The case goes back to the 11th Circuit to sort out whether government decisions or mistakes can still be challenged under state law. Stick around to hear how this could shape future fights over holding the government responsible. Nine Robes uses nonpartisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided, it's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. On October 18, 2017, FBI agents made a serious mistake. Intending to execute warrants at 3741 Landau Lane, they instead raided 3756 Denville Trace in suburban Atlanta. The agents deployed a SWAT team, detonated a flashbang grenade, handcuffed the occupants, and assaulted them before realizing they were at the wrong address. Katrina Martin, Hilliard Toy Cleat, and their child sued the United States under the Federal Tort Claims Act, FTCA, alleging both negligent and intentional wrongdoing. The district court granted summary judgment for the government, and the 11th Circuit affirmed using a unique approach. The Supreme Court then agreed to hear the case to decide two key questions. One, whether the FTCA's law enforcement proviso applies beyond just intentional torts, and two, whether the Supremacy Clause gives the government any defense in these types of lawsuits. Justice Gorsuch, writing for a unanimous court, held, 1. The law enforcement proviso in the FTCA only limits the intentional tort exception in that same subsection, not the discretionary-function exception or any other exceptions. The proviso appears in the same sentence as the intentional tort clause, refers only to this subsection, and specifically addresses claims for assault, battery, false imprisonment, false arrest, abuse of process, or malicious prosecution by investigative or law enforcement officers. 2. The Supremacy Clause does not provide the United States a defense under the FTCA. The FTCA itself is the supreme federal law on tort liability for federal employees, making the government liable under state law on the same terms as private individuals. No federal statute or constitutional provision displaces Georgia tort law in this case. The court vacated the lower court's decision and sent the case back to the 11th Circuit to determine which claims survive without reference to the law enforcement proviso, and for remaining claims, whether Georgia law would impose liability on a private person under like circumstances. Justice Sotomayor, joined by Justice Jackson, filed a concurrence emphasizing that the 11th Circuit must apply a two-step test when reevaluating the discretionary-function exception. First, ask whether the acts involve judgment or choice, not limited by specific federal directives. Second, determine whether the judgment involved public policy considerations that Congress intended to shield. She highlighted the ambiguity in lower courts over whether careless conduct or constitutional violations fall outside the exception, and urged the court to consider the FTCA's legislative history, especially its enactment in response to wronghouse raids, to ensure victims of law enforcement misconduct have proper remedies. The Federal Tort Claims Act, FTCA, allows people to sue the federal government for wrongdoing by its employees, but with important limitations. The Act contains several exceptions that protect the government from liability in certain situations. At issue in this case was how two of these exceptions interact. The intentional tort exception normally prevents lawsuits against the government for intentional wrongdoing like assault or false imprisonment. However, a special provision, the law enforcement proviso, creates an exception to this exception, allowing people to sue when law enforcement officers commit these specific acts. Separately, the discretionary-function exception protects the government from liability when employees exercise judgment in their official duties. The court clarified that the law enforcement proviso only modifies the intentional-tort exception, not the discretionary-function exception. This means that while victims can sue for intentional misconduct by law enforcement officers, the government might still be protected if the actions involved discretionary judgment. The court also rejected the government's argument that the Supremacy Clause provides additional protection beyond what's specifically listed in the FTCA. Instead, the government is subject to the same liability standards as private individuals under state law, with only limited defenses specifically provided in the law. This framework preserves both the right of victims to sue individual officers and their right to recover damages from the United States under state law standards that Congress chose to adopt in the FTCA. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.